In the matter of Crown against Hayes and Crown against Palombo.
Lord Leggett will explain the Court's judgment.
These are appeals brought by two individuals, Tom Hayes and Carlo Palombo, against their convictions for offences of conspiracy to defraud. Each of them was accused of conspiring with others to manipulate key benchmark interest rates used in financial markets. In Mr. Hayes' case, the London interbank offered rate, LIBOR, and in Mr. Palombo's case, the Euro interbank offered rate, EURIBOR. Mr. Hayes was convicted at a trial in August 2015. He was sentenced to 14 years imprisonment, reduced on appeal to 11 years. Mr. Palombo was convicted at a trial in March 2019. He was sentenced to 4 years imprisonment. In each case, an appeal against conviction was dismissed by the Criminal Division of the Court of Appeal. One of the grounds on which Mr. Hayes sought to appeal against his conviction was that the judge had misdirected the jury about what they had to decide, with the result that an essential question of fact had been removed from the jury's consideration. The Court of Appeal rejected that argument. Directions given to juries in later cases, including at the trial of Mr. Palombo, followed the same general approach as the directions given at the trial of Mr. Hayes. In 2023, the Criminal Cases Review Commission referred the convictions of Mr. Hayes and Mr. Palombo back to the Court of Appeal after a court in the United States decided a similar LIBOR manipulation case differently, which led to convictions being quashed and charges dropped in the United States. On these second appeals to the Court of Appeal, counsel for Mr. Hayes and Mr. Palombo tried once more to argue that the judge's directions to the jury at their trials were wrong in law. The Court of Appeal decided that the appellant should not be allowed to make this argument because it did not relate to the reason for the reference from the Review Commission, and in any case, it had already been considered and rejected as a bad argument by the Court of Appeal on previous occasions. So the Court of Appeal dismissed the appeals and upheld the convictions. As the law stands, it is only possible to appeal to the Supreme Court in a criminal case if the Court of Appeal certifies that the decision involves a point of law of general public importance. Here, the Court of Appeal did certify that a point of law of general public importance is involved, and the Supreme Court granted permission to appeal in both cases. For the reasons given in the judgment handed down today, the Supreme Court unanimously allows both appeals and quashes the appellant's convictions. The judgment is given by myself, Lord Leggett. The other justices agree with it. LIBOR was a benchmark rate of interest published each day for a variety of currencies and borrowing periods. It was used as a reference point in many financial transactions, including interest rate swaps and other derivatives. The daily LIBOR rates were calculated from figures submitted by a panel of banks. Each bank on the panel was asked to submit the rate at which it could borrow funds for a particular borrowing period in a particular currency at the time of the submission. From the figures submitted, a trimmed average was calculated to produce the rate published as LIBOR for that day. EURIBOR operated in a similar way as a benchmark rate of interest for the euro, with the slight difference that panel banks, instead of submitting the rate at which the bank making the submission could borrow funds, were asked to submit the rate at which a, quote, prime bank could borrow funds. Identifying the rate at which a bank could borrow funds at the specified time was not simply a matter of reading a number off a screen. It required a subjective assessment of various data sources and was a matter on which there could legitimately be a range of opinions, particularly as the number submitted had to be stated to at least 2 and sometimes 5 decimal places. Such fractional differences could nevertheless affect whether money was gained or lost in trading instruments linked to LIBOR or EURIBOR on financial markets. From around 2008, regulators in the United States and the United Kingdom began to investigate allegations that panel banks, or traders within those banks, were attempting to manipulate LIBOR and other benchmark rates of interest by submitting figures which were designed to skew the published rate to their commercial advantage. In 2012, the Serious Fraud Office began criminal investigations. The first person to be prosecuted was Mr. Hayes. Further prosecutions followed. As well as Mr. Hayes, those prosecuted and convicted at a trial included Mr. Palombo, who was charged with a conspiracy to defraud in relation to EURIBOR. In each case, the Serious Fraud Office alleged that the defendant had dishonestly agreed with others to procure or make submissions of rates for use in setting LIBOR or EURIBOR, which were false or misleading in that they were intended to create a trading advantage and deliberately disregarded the proper basis for the submission of those rates, thereby intending to prejudice the economic interests of others. An essential part of the prosecution case was that the defendant had agreed with others to procure submissions of rates which were, quote, false or misleading. Because, as I have mentioned, the answer to the question about the rate at which a bank could borrow funds in the specified currency for the specified period at the specified time was a matter of opinion, the submission of a rate could only be false or misleading if it did not represent the genuine opinion of the person responsible for submitting the rate on behalf of the bank. What opinion that person, the submitter, actually held about the borrowing rate and whether that rate accurately reflected that opinion were questions of fact, which in a criminal trial are a matter for the jury to decide. In his defence, Mr. Hayes admitted that when there was a range of potential borrowing rates, he had tried to influence submitters to put forward numbers within that range which would advantage his trading. But he denied that he had attempted or agreed with others to influence submitters to put forward rates which did not represent their genuine opinion. At Mr. Hayes' trial, the judge directed the jury that if any consideration at all had been given to whether the rate submitted would be to the commercial advantage of the bank or a trader, then, as a matter of law, the rate submitted could not be a genuine or honest answer to the question posed by the LIBOR definition. As it was not disputed that Mr. Hayes had asked submitters to put forward rates intended to advantage his trading, the effect of the judge's directions was to instruct the jury, as a matter of law which they had to accept from him, that Mr. Hayes had agreed to procure the submission of rates which were not genuine or honest assessments of the bank's borrowing rate and were therefore false or misleading. As explained in detail in the judgment given today, that was an error. The law could not dictate whether or not the rate submitted represented the submitter's genuine opinion of the relevant borrowing rate, nor whether Mr. Hayes had agreed to procure submitters to put forward rates which did not represent their genuine opinion. These were questions of fact which should have been left to the jury to decide. The jury might well have regarded the fact that a rate submission was influenced by trading advantage as supporting an inference that the figure submitted did not in fact represent the submitter's opinion of the rate at which the panel bank could borrow money at the relevant time. But it was for the jury to decide whether to draw that inference, and not for the judge to tell them that they must do so because the law required it. Mr. Hayes was entitled to have his defence to the allegation that he'd agreed to procure the submission of rates which were false or misleading considered by the jury. He was deprived of that opportunity by directions which were legally inaccurate and unfair. Although there was ample evidence to support the prosecution case, it is not possible to say that if the jury had been properly directed, they would have been bound to return guilty verdicts. Mr. Hayes' convictions is therefore unsafe and must be quashed. In Mr. Palombo's case, the jury directions given at his trial are not open to the same degree of criticism, but they still involved the same essential error of treating a question of fact as if it were a matter of law. Compounded with other errors and ambiguities in the directions, the result is that Mr. Palombo's conviction is also unsafe and must be quashed. This court therefore allows both appeals.
The court is now adjourned.